Welcome to WG University, Weber Gallagher's series of educational programs. This is our employment webinar series. I am Julie Kinkoff, and I am presenting today with Danielle Burke from our Philadelphia office. If you would like to view this webinar again, share it with others, or see other WG University programs, please visit the Weber Gallagher webpage at www.wglaw.com, and you will find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions at questions@wglaw.com. Today's presentation is the hiring minefield. What can you ask these days?
Okay, so today we're going to discuss three issues: health inquiries, salary history questions, and criminal background inquiries. All right, let's get started.
So let's start first with the medical questions. Danielle, what are the laws that govern medical questions in interviews?
Well, the federal law is the Americans with Disability Act, or ADA as it's usually called, and that applies to 15 or more employers who have 15 or more employees, including state and local governments. There's also New Jersey's law against discrimination, which applies to all employers regardless of their size, as opposed to federal court where you have to go through an administrative process. In New Jersey, you can go straight to state court without any agency action. New Jersey's law has a 2-year statute of limitations on it.
So under the federal law, if someone wants to make a complaint, they first have to go to the EEOC.
Yes.
But in New Jersey, they don't have to. They can go straight to court, right?
No, they can go straight to court without any agency action.
Okay, so let's talk about pre-offer inquiries, and we're going to focus really right now on the ADA. It's important to understand that the ADA applies from the beginning of the hiring process. So anything related to advertising, recruitment, and interviewing must comply with the ADA. And in order to comply with the ADA, you cannot ask disability-related questions or give a medical examination. So what's a disability-related question? A disability-related question is a question that is likely to elicit information about a disability. It's also important to understand that it's the question itself that's the violation. A person does not need to be disabled in order to bring an ADA claim for pre-offer inquiries. So what can you ask? And this is all pre-offer, and we're going to talk about what an offer is in a little bit, but this is all pre-offer. So this is as part of the beginning of your interviewing and application process. You can ask someone whether they are able to perform the specific functions of the job with or without accommodations. You're not allowed to ask them about anything having to do with any medical condition or disabilities. You're also not allowed to ask them about the workers' compensation history, and you're not allowed to give medical exams. Now, you can't ask about workers' compensation history because that could lead to information related to disability. It's also important to understand that if you can't ask the applicant the question, then you also cannot try to get the information via another source, like a background check or a reference check or anything like that. So now, what about medical examinations?
Okay, so for a medical examination, you're allowed to do certain things regarding the ability of that person to do the functions of their job. Say you ask someone to move a box 40 feet. You're allowed to do that as long as it's part of the job description and the duties associated with the position that they're applying for. However, if after they move that box a couple feet, you try to take their blood pressure or you try to take their heart rate associated with the moving of the box, that's going
to get you in trouble.
Yeah, that'll get you in trouble.
Okay, so long as it's related to the job, a physical aspect of the job, you can ask somebody to maybe lift something off their head or lift a certain amount of pounds or something like that.
Yeah, as long as the test isn't like an invasive test like blood work or urine sample or a test along those natures, you're allowed to do as long as it's associated with the functions of the position and it's not trying to ascertain whether or not they have a physical or mental disability.
Okay, so now what about personality tests? Some employers use those in their hiring process.
So you are allowed to do personality tests as long as it's not trying to ascertain whether or not someone has, say, depression or anxiety, but whether or not
any of those DSM things.
Yeah, exactly.
So could you have a personality test that determines whether, or kind of helps to determine whether somebody is honest?
Yeah, absolutely. So if it's to determine whether or not someone's lying as opposed to whether or not they have a mental disability, you're allowed to give that personality test. Now, another question may arise when someone has a known disability. Say, for example, someone's in a wheelchair and they're applying for a position.
Then what do you do?
You can ask them questions regarding whether or not they're able to do the functions of the position, but you're not allowed to ask them about the underlying condition that they have. So for an example, say someone was applying for a position to repair washers and dryers, and they came and they had one leg. You're not allowed to ask them about their condition, but you are allowed to ask them if they can actually perform the functions, if they can take the...
Well, like my washer and dryer and a lot of people's is in the basement, right?
Exactly. So you're allowed to ask them if they can demonstrate whether or not they're able to carry the tools and stuff necessary for repairing the washer and dryer and make their way downstairs with these tools and do the functions of the job.
Okay, so let's talk about an example related to that. Let's say that you are interviewing someone for a position that involves in computer work. Mm-hmm. Alice comes in, and Alice appears when she comes in to have a severe visual impairment. Can you ask Alice if she will need a reasonable accommodation to perform the functions of the job?
Yes.
Yes, you can. So what if Alice says yes? Then what do? Can you ask questions about that accommodation? And the answer to that is yes, you can. If she, for example, is going to need a certain computer program or something like that would assist her to do the job, then you can ask about that computer program and see if your computer system can accommodate it and that sort of thing. So let's play a little game called Legit or Lawsuit. First question. These are all questions. The question is, can you ask them? And if you ask them, is it a legit question or a lawsuit? Will you require a reasonable accommodation to perform this job? Now, this is kind of a little bit of a trick question because earlier I said you could ask if they could perform specific functions, but this isn't asking about specific functions. Mm-hmm. This is just asking about performing this job. So according to the EEOC, this is not a legit question. This question could lead to a lawsuit. Next one, how many days were you absent from your last job? This is a legit question, according to the EEOC. And of course, the EEOC is the agency that enforces these rules. The reason why this one is a legit question is because there's lots of different reasons why you may be absent from your job. Mm-hmm. They have nothing to do with your health.
So if you have kids or something like that and you're going to activities for them, or you have a child who's sick sometimes.
Right, but can you ask somebody how many days were you sick last year?
No,
that would not be good. Have you ever filed a workers' compensation? This is an easy one. No, of course you can't ask that question. What about this one? Are you currently using illegal drugs? According to the EEOC, you can ask this because the ADA does not protect the use of illegal drugs, including medical marijuana or any sort of marijuana, because marijuana under federal law is still an illegal drug. Okay, so we've all been talking about what you can do before an offer is made. What's an offer?
Well, a job offer is real if the employer has evaluated all of the relevant non-medical information, which it reasonably could have used and obtained prior to giving the offer. Now, a question may arise whether or not an employer can give multiple job offers that exceed the number of vacancies.
So you're hiring for one position, but can you give out 3 offers?
And the answer is yes, but as long as you can demonstrate that you actually need to give multiple offers in order to fill the vacancy or the reasonably anticipated opening. So
if it normally takes you 3 people to fill one position, then it's okay to give 3 offers.
Absolutely.
Okay. So now after the offer, what can you do after the offer? After an offer has been made, you can ask disability-related questions or require medical examinations, so long as it is done for all entering employees in that job category. Now, you also can ask for documentation related to the disability and about reasonable accommodations. Okay, but whenever you're talking about anything related to employment, you have to be careful about confidentiality. It's important to keep in mind that you must keep medical information on applicants and employees confidential. There are certain exceptions, and that may be, so for example, if somebody is hired and they are going to have an accommodation, supervisors and managers may be told about the restrictions or the accommodation, but they shouldn't be told about the medical condition itself. Also, if there's something about the medical condition that might be relevant for first aid or safety personnel to know if they needed to administer medical treatment, emergency medical treatment, then they can be told.
So like if someone has diabetes or something along those lines, you could tell the emergency medical personnel that this person has diabetes. It might be low blood sugar. It might be something related to that.
Right, or maybe like a blood clotting issue or something like that. Okay, so what is the EEOC position on disability-related questions?
So if an employer rejects an employee after asking a disability-related question or a medical examination, the EEOC is going to strictly look at that and determine whether or not it was based upon discrimination. So you have to be extremely careful regarding this. But what kind of steps can you take to ensure that if you do reject an employee after making that determination who does have a disability, that you don't insert?
So once you've asked medical questions and you've used the information that you've obtained to make an adverse employment decision, you need to make sure that the reason for the rejection is job-related and consistent with business necessity. So it has to be specifically related to the job, and it has to be related to business necessity. Now, that might be sometimes hard to do, and you need to be really careful. So if you are going to reject somebody who you know has a disability, probably a good idea to talk to an employment lawyer before you do so. Also, if you are going to reject somebody because, for safety reasons, in that case, you have to show that there's a direct threat and that threat cannot be reduced through reasonable accommodations. So let's see. Let's talk about some areas where the EEOC has had settlements or issued decisions on these matters. Mostly settlements. This is definitely an area that the EEOC sees as kind of low-hanging fruit. And just give you an idea of some things that have gotten people in trouble in the past. There was a trucking company who refused to hire a veteran who suffered from post-traumatic stress disorder and needed a service dog. And the reason why they said they wouldn't hire him was because they had a no pet policy. Now, that got them in trouble for obvious reasons. Obviously, a service dog is not a pet, and they should have handled that differently. And because they handled it the way they did, it cost them nearly $50,000. Another example, so as kind of a cautionary tale, is a phone interview that was with an applicant. And during the phone interview, the applicant who was applying for a customer service position, like a customer service, like a support position that you use a computer, not out in the field type thing. But as part of the phone interview, the applicant said that she was in a wheelchair. The person who was doing the phone interview abruptly ended it.
Immediately after she told him that she was in a wheelchair?
That's what the EEOC said in its settlement. And that one cost that employer $50,000. And the employer also had to do a 2-year consent decree, had training obligations, notices had to be posted, and modifications of its policies. So sometimes with these EEOC settlements, it's as painful as the money is, it's the non-monetary provisions of the settlement that can really be painful to employers. So that is definitely something you want to watch out for. So it's important to take these medical questions seriously. So now we're going to switch gears here a little bit.
Okay, and we're going to talk about salary history inquiries. Now, what is the reason that we have salary inquiry?
So now salary history inquiries, these are the inquiries like asking people what they made in their current job. So like, what are you making now? And the reason why jurisdictions are banning this question is that it perpetuates gender and racial disparities in compensation. So employers make decisions based on what people already make, which just perpetuates the wage gap. Women earn 82 cents for every dollar that a man earns. And when you talk about women of color, the gap is even worse. These numbers are from when New Jersey passed their law, the legislative findings. 58 cents for Black women for every dollar that a man earns, and 43 cents for Latino women. According to Governor Murphy, when he signed the law, the discriminatory wage gap results in lost wages exceeding $32 billion every year in New Jersey. That's a lot of money. So what's the current state of the law?
Well, in federal court, there is no ban currently. Philadelphia has a partial ban. They used to have a full ban, which disallowed an employer from asking questions about salary and using the salary in determining compensation later on for that employee. Now, Philadelphia only allows people to not use the prior history for salary for compensation going forward.
Now, that law was challenged.
It's challenged.
Before the Third Circuit,
currently
right?
before the Third Circuit regarding the First Amendment constitutionality.
So like from a kind of legal nerd standpoint, the Third Circuit said that you could ask the question. That was a First Amendment right, but you couldn't use the information.
Exactly. So
that's what the district court said.
You're allowed to have the information, but you can't use the information in Philadelphia currently. Like I said, it's currently on appeal, so we'll see where the Third Circuit goes with that.
So for now, employers should be very careful about asking that question in Philadelphia, because how are you going to show that you didn't use the information?
Absolutely. That's going to be the question that everyone has.
Right.
So.
And what about New York, our neighbors to the north and our neighbors to the south?
Well, New York City and Delaware currently have bans. New York currently has approved a ban, but it's not effective until January 6, 2020.
So this is kind of breaking news here,
Breaking news, guys.
From for New York.
It just got passed July 10th of this year, 2019. So it's effective January 6, 2020. So if you're in New York and you're going to be practicing in that state and you're an employer, you need to make sure that you're complying with this and you're not going to be asking salary history of your applicants or employees moving forward.
Now, what about New Jersey? Now, they have a change in the law over there
New
too,
Jersey
right?
just changed their law recently as well, and it's becoming effective January 25th, 2020. And it's the same thing. It bans employers from screening a job applicant based upon their salary history. But it also forbids an employer from requiring that the applicant's salary history satisfy a minimum or maximum criteria.
So this is an area, the salary history questions area is certainly an area that you need to watch out for changes in the law. Because this is a hot area and a lot of legislatures are getting involved.
Absolutely.
Okay, so let's switch gears again and let's talk for a second about ban the box laws. So what are ban the box laws? These are laws that prevent an employer from requesting criminal history information. So it used to be a box on applications. Have you ever been convicted of a crime? That's why it's called ban the box. Ban the box law require employers to consider a job candidate's qualifications first, without the stigma of the conviction or arrest record. Most laws permit inquiry into criminal records after a conditional offer is provided, but some exceptions apply. And other laws may have to do with not with a conditional offer, but maybe with an application or with a interview. But these areas, so let's talk about, I mean, this is another area of the law that kind of is changing quickly, but let's talk
Absolutely.
about what's the current status.
Well, federal law doesn't have a ban right now. Delaware, Pennsylvania, and New York have bans for public employers only. So private employers don't have bans, but local places like Pittsburgh and New York City have local laws which apply to both private and public employers.
And Philadelphia has its own law, which we're going to talk about in a second. But the other thing to keep in mind here in Pennsylvania is Pennsylvania has a criminal history record information law. And so that has to do with not necessarily the box, but what you do if you have the information. And it requires that information regarding convictions only relate, that you use that information only as it relates to suitability for the position applied for. And it also requires some notices be given if an adverse decision is made based on criminal history and information. Okay, so let's talk for a second about New Jersey. What's the status right now in New Jersey?
So right now, New Jersey has a law which forbids employers from asking criminal statutes or criminal history regarding both private and public employers. Both of them are banned from this. An employer has to have 15 or more employees over 20 calendar years. They can't
Calendar weeks.
Calendar weeks, I'm sorry. They cannot publish advertisements that state that an applicant with a criminal background will not be considered for the employment, and they can't inquire into the candidate's criminal background in an initial written application or during the interview process. But after the initial interview application process, the employer can look into a candidate's criminal background.
Okay, so now over here in Philadelphia, if you do hiring in Philadelphia, there is a really robust ban the box law here. First of all, no criminal background checks prior to a conditional offer. Once you get that criminal background check, you have to be careful as to what you consider Only convictions that have occurred in the less than 7 years can be considered, and that there is a carve out there for people who have been incarcerated. The 7 years doesn't count the time that they were incarcerated. And you have to go through an individualized assessment process when considering a criminal background in Philadelphia. Now, also, if an applicant voluntarily discloses information regarding criminal convictions during the application process, you may discuss the conviction that is disclosed.
But you can only discuss convictions, not arrests?
Right, that's correct. So the bottom line when it comes to criminal background checks is that you want to be careful to know where you're hiring and what the law is in the area where you're hiring. You want to be sure to comply with all the notice requirements. The Philadelphia law also requires that if you make an adverse determination because of a criminal background, that you provide notice, written notice to the person. And you want to just make sure that you're complying with the local laws where you are, the state laws, and also the federal laws, which is kind of beyond what we're talking about here, but the Federal Credit Reporting Act is something else you want to make sure. So now, have there been settlements or anything like that where people have gotten this wrong?
Yes, absolutely. So there have been 2 large retail stores that were required to pay $100,000 and $95,000 associated with using a criminal background check while using their employment and determining employment obligations and whether or not they're going to hire someone.
So again, this is another thing. This is another costly mistake.
Absolutely, and they have the same injunctive relief that you discussed earlier, where they have to go forward and implement certain training and make sure moving
Consent
forward.
decrees and all that.
Yes, so it's the same type of avenue where they have to go with training and making sure that they comply from that point forward that they've signed on to.
And the last thing you want is the EEOC looking at all of your hiring practices because you're under a consent decree. So, all right, so that is what we have today. If you have any questions, you can send questions to the wglaw.com.
Thank you for attending the webinar, The Hiring Minefield, What Can You Ask These Days? You can learn more about this program and other Weber Gallagher events at www.wglaw.com/WG-University.
Thank you. Have a great day.
Thank you.